On est prêt. Alors, c'est avec un énorme plaisir que je déclare ouverte aujourd'hui, non pas la rentrée judiciaire, mais bien la tout aussi importante reprise de notre cycle de conférences sur la recherche en droit. Soyez les très bienvenus. J'espère vous voir souvent dans cet espace d'échange et de partage d'idées. J'espère que vous avez passé un bel été. Et donc, on va commencer aujourd'hui. J'ai le grand plaisir de vous présenter M. Stephen Bindman. Je vais lui présenter brièvement, d'abord un peu en français, après en anglais. La conférence se déroulera en anglais. Pour la période des questions, si vous voulez les poser en français, il me fera plaisir de les traduire.
Je n'ai pas besoin de traduire ça.
Ah, bon, tant mieux. Alors, voilà. Vous savez que nous sommes fortement engagés à la section de droit civil à la promotion d'une culture de recherche ouverte sur le monde, ouverte sur la cité, et donc un dialogue avec des partenaires privilégiés comme le gouvernement ou d'autres acteurs sociaux ou groupes dans la communauté. Et notre premier invité illustre cette collaboration. Il est conseiller principal à Justice Canada et chercheur invité à la Faculté de Droit, une initiative de la section de Common Law. Alors, pour aujourd'hui, M. Bindman traitera du thème des condamnations injustifiées au Canada, pourquoi elles se produisent, quel est leur taux de prévalence, qu'est-ce qu'on peut faire pour les empêcher et pour apporter une logique de droit de la personne dans ce domaine si important. Tout en collaborant avec nous, M. Bindman reste conseiller principal en politique au secteur du ministère de la Justice du Canada, spécialisé dans les condamnations injustifiées. Il a coordonné la production du rapport sur la prévention des erreurs judiciaires, publié en 2005 par les ministres fédéraux, provinciaux et territoriaux responsables pour la justice, et la suite de ce travail important, publié en 2011 sous le nom « Un système plus juste, la voie vers l'élimination des condamnations injustifiées », dont la suite est sortie tout juste l'année passée avec le titre « L'innocence en péril, la nécessité de vigilance continue afin de prévenir les condamnations injustifiées au Canada ». M. Bindman co-préside aussi le sous-comité fédéral, provincial, territorial des chefs des poursuites pénales sur la prévention des erreurs judiciaires. Jusqu'en 1998, il était le correspondant national pour les affaires juridiques au Southern News, basé à Ottawa. Il a rapporté régulièrement sur la Cour suprême du Canada, la Cour fédérale, le ministère de la Justice et le système judiciaire pour plus de 30 journaux à travers le Canada. Il a contribué à de nombreuses publications juridiques et était paru régulièrement à la télévision et à la radio en tant que commentateur juridique. He is a former president of the Canadian Association of Journalists and has been a governor of the National Newspaper Awards and Canadian Journalism Foundation. He graduated from Carleton University in Ottawa with joint honors in journalism and law in 1983. He was awarded a Southam Fellowship and studied law and criminology at the University of Toronto, and in 1995 was awarded a fellowship from Yale Law School to study for a master's in legal studies. He says, unfortunately, he still owes Yale 2 papers. So, je vous laisse donc avec notre invité aujourd'hui.
Merci Margarita et merci pour l'invitation à vous parler aujourd'hui. I'm sorry my French isn't good enough to carry through the whole presentation in French, but I'd be pleased to take your questions in French, whether I answer them in French or not. We'll see how hard the question is. Margarita mentioned that my appointment as visiting fellow is part of the common law section. I had lunch this summer with Marie-Ève, and we decided, without the paperwork, I'm going to be cross-appointed to the civil law section. So I hope I'll be seeing a lot. I hope I'll be seeing a lot of you over the course of. I'll be here for at least another year, so I look forward to it. I should also say at the outset, I'm required to say that any views I'm expressing today are my personal views and not those of the Government of Canada or the Department of Justice. And if someone can send an email to J. Trudeau, if you could just let him know I said that, we'll all be better. I'm just curious, did any of you watch Making a Murderer on Netflix? So a few, okay. I did a presentation to a National Judicial Institute course for judges on wrongful convictions, and I think they all put their hand up when I asked that question. So they're sensitive to that. My title is now Senior Advisor at the Department of Justice, but for the longest time my title was Special Advisor on Wrongful Convictions, and I was doing that. It's probably about 12 or 13 years that I had that title. And you know, when you're starting out on a new job, you get all sorts of good luck messages from your colleagues. You know, good luck, I think you'll do well. So I got those, but there's also one other one that I got, and it was actually, I have the date here, June 3rd, 2005. And I'm going to show you it's actually an email. And this is what one of my colleagues wrote, and a very senior colleague, in fact. He said, "By the way, I find your new title more than a bit unusual from a communications perspective. The normal approach for any organization is not to openly admit that there are major problems. You deal with them as an organization, but you do not publicly admit your incompetence. By analogy, and according to that logic, if we were in the medical profession, your title should be Special Advisor Botched Operations. I think it would more likely be in reality Special Advisor Improvements of Operating Procedures. You will likely respond that we chose to be candid about wrongful convictions, but from my perspective, I see that as evidence that we are losing the most basic survival instincts as an organization. Just one more thing that you and I will continue disagreeing on, I suppose." So obviously I completely disagree, and in fact, I think the only way we're going to prevent wrongful convictions is by talking openly about them, acknowledging they occur, and trying to understand their causes and what we can do to prevent them. And I guess the central message that I want to leave you and my students and other people I talk to about wrongful convictions with is that wrongful convictions regrettably do occur. And in fact, I think they occur probably more frequently than many of us would like to acknowledge. And as legal professionals, whether in the academy, whether as judges, whether as lawyers, we need to constantly be on guard against the factors that can lead to wrongful convictions. Now, perhaps I'm a bit different than some of the people who are more directly involved in the innocence movement. And I think most of the time, at least in Canada, the system does work. And you know, most guilty pleas are in fact justified. And I don't think I would call it a crisis or an epidemic. But I do believe we have to openly and publicly acknowledge that they are part of our system. And the more I talk to people about wrongful convictions, I still get a bit of pushback on that sort of fundamental concept that wrongful convictions are part of the system. And I guess I still don't get it. So as you know, our system is a system based on humans. Facebook and Google, they haven't yet, maybe it's coming with AI, but the justice system isn't a machine that you can just plug in the evidence at one end and out comes the correct verdict at the other. Think of how many different individuals are involved in any one case, literally dozens, if not hundreds. Witnesses, police officers, scientists, prosecutors, lawyers, judges, jurors. If even one of them makes an error, intentional or not, then things can break down and a wrong result may occur. I read recently a comment. It was in connection with a different thing, but it resonated with me. And it said, there is no inherent reason that police, prosecutors, and judges ought to be more or less fallible than other government employees, like those who work in defense procurement or in energy policy. On the other hand, incompetence or malfeasance in the criminal justice system has such catastrophic consequences for the falsely accused that it ought to shock and appall. So let me tell you what I hope to talk about today. I may not get to all of it, we'll see. These are the faces of some of the wrongfully convicted in the United States. I'll show you some Canadian faces, and just from a quick look at the pictures, you'll see a pattern that I'll talk about in a little bit. So I want to talk a little bit about what's a wrongful conviction, talk about some statistics, talk about the impacts of wrongful convictions, and they're perhaps, some are obvious, some are less obvious. Talk about how I think Canada compares to the United States. Maybe talk briefly about, depending on how much time we have, about causes, and some closing thoughts. This is Jerry Miller, who spent 25 years in prison. 25 years. I mean, I venture to say there may be some people in this room who aren't 25 years old. So he spent 25 years in prison for a rape he didn't commit. And this is what he said, and he likened the justice system to a big assembly line. And I know it's an analogy many of us who work in the criminal justice system might be uncomfortable with, but he says, lots of products come off, and most of the time it's okay. But then there's the defects, the ones that are messed up. You got an assembly line, you're always going to have some defects. So I've been talking about wrongful convictions, as I say, for probably almost 15 years ago. And I think that there's much less of the attitude of my colleague that I referred to earlier, of sort of the refusal to acknowledge the existence of wrongful convictions. And increasingly, I think the judicial community, like everybody else, are starting to recognize that indeed wrongful convictions, are part of the system. They're not just isolated one-offs. And I think you'll see maybe a little bit in our presentation today that there are things that can be done at all phases of the judicial system to prevent wrongful conviction. A colleague of mine says it's like the first in the 12-step program for alcoholics. You need to acknowledge you have a problem. And so while I think there's still a lot of work left to be done, I think we have made at least a lot of progress on the first step. And I'm not naive, and I don't want to sugarcoat the message that no, not everybody gets it. And yes, there will be legal fights that many of us wish we wouldn't have, and not every case is going to end well. From my experience at work on wrongful convictions at federally and provincially, I would say the issue now is not so much getting people to acknowledge that wrongful convictions occur, but rather it's none of their cases are wrongful convictions. So some prosecutors, I read recently, quote, would burn the world down before they admit a mistake. So yes, there's an understanding that wrongful convictions occur. It's a little more difficult, and I'm involved in a case in Nova Scotia now, and it's really hard to get people, despite the obvious facts, to acknowledge wrongful convictions. I think one of the things we need to understand about wrongful convictions is that they're systemic errors. So as this writer says, yes, the cops got the wrong guy to confess, but someone trained the cops and set their resources. The prosecutors failed to screen the case. The defense didn't intercept the mistake. The courts waved it along. At some distance away, someone equipped these players, set their incentives, and limited their options. Even when there are culpable actors, there is a range of others who also contributed, who zipped when they should have zagged for reasons that made sense to them at the time and are revealed as dangerous only by hindsight. What conditions motivated them? Do those conditions still exist? So they're systemic problems, and it's not a case, I think, of trying to attach blame to any one player in the system. And as one writer wrote, the essential fact is that we are generally that wrongful convictions are generally invisible. If we could spot them, they'd never happen in the first place. So why would anyone suppose that the small number of wrongful convictions we do learn about years later is anything more than an insignificant fraction of them all? And I'm not going to get religious on you, but there has been a recent interest in wrongful convictions, sort of dating around 1989, which was the first time DNA was admitted in court system in the common law world. So a lot of the counting that you'll see as we move on starts from about 1989. But just to let you know that the concern about wrongful convictions isn't something new. Anybody for a skill testing question know where the first one's from? Other than Exodus. It's one of the 10 Commandments. So you shall not bear false witness against your neighbor, and so on. So it's not something new. What is a wrongful conviction? And part of the difficulty in research and writing about wrongful convictions is everybody is counting something different. And it goes back in part to what I mentioned earlier about people refusing to acknowledge that in fact it's a wrongful conviction. But the definition I use, and I'm going to tell you why it's under review in a second, is a person who is found guilty of a crime they did not commit and whose conviction is not remedied through the ordinary court processes in a reasonable period of time. So found guilty, so we're not talking about people who are just charged and the charges are dropped or whatever. So they have to be found guilty. They did not commit. So we're talking about what is termed in the literature factual innocence. So either the crime, either they got the wrong person or they didn't do it, or there is a category of cases of where there was no crime. So it wasn't a question of the wrong person, but there was no crime. So one of the cases is a case from Nova Scotia of a gentleman who was convicted of pushing his wife down some stairs, and subsequently it was proven through science that in fact she had fallen and wasn't pushed. So it wasn't the fact that somebody else pushed her, it was the fact that there wasn't a crime in the first place. And this is the controversial part, whose conviction is not remedied through the ordinary court processes in a reasonable period of time. So under this definition, if someone is convicted and then as part of the appeal process, the conviction is overturned and factual innocence is proved, until my definition was under review, that wouldn't be considered a wrongful conviction, because theoretically, at least, the system has worked. So that's what the appellate process is for, to try and repair correct convictions. But let me tell you why I've had second, and I use the reasonable period of time addition because there are cases where, yes, it's the appellate process that overturns the conviction, but it takes forever, and hard to argue with someone who's languishing in prison for years, and the appellate process works, but it takes forever to work. Guy Paul Morin, you may be familiar with. So his conviction was overturned through the appellate process, but it took 10 or 11 years. So it's hard to argue that that's not a wrongful conviction. But let me tell you why it's under review, and it's a result of a Court of Appeal case last year called Catchaway, C-A-T-C-H-E-W-A-Y. So Mr. Catchaway was arrested September 9th, 2017 for a series of break and enters or being unlawful in a dwelling house or whatever it was in Winnipeg. He pleaded guilty on November 9th, and he was sentenced on January 9th. He had previous records. He had a very bad upbringing. And he got some jail time, I can't remember what it was. So arrested September 9th, pleaded guilty, remember, pleaded guilty November 9th, sentenced January 9th. But then, after January 9th, somehow I think his new lawyer discovered that on September 9th, when the offense was alleged to have occurred, he was actually in jail in Brandon, Manitoba, which, I don't know if there's anybody here from Manitoba, from Winnipeg, but it'd be pretty hard to make it from, just to go to the washroom in Brandon and say, I'll be back in an hour, and commit the... So on May 10th, in a really boring judgment, the Manitoba Court of Appeal overturned the conviction and said, so he pleaded guilty. So under my previous definition, it was remedied through the ordinary court process. It was remedied in a process of about 5 months, which is hard to argue with. But it's hard to argue that that person wasn't wrongfully convicted. So I'm going back to the drawing board if afterwards in the discussion period, if people have any suggestions on how I get around this dilemma. I'm just going to, I left these slides in. I mentioned earlier that I'd done a similar presentation at the National Judicial Institute to judges, and the judges are really into this technology where you get to vote. They love to play with technology, except in their courtrooms, but they love to vote. So I left in the questions I asked them, and the first one was, what was the leading cause in the first 330 U.S. post-conviction DNA exonerations? 1, unvalidated or improper forensics, B, eyewitness mis-ID, C, false confession, or D, use of a jailhouse informant. I'll try it out on you. Just put up your hands. Who thinks it's A? B? C? D? Okay, the correct answer you'll see in a second is B, actually, by an overwhelming amount. So the judges got it right, though, so I don't know what that says. So assuming we can agree on a definition of wrongful convictions, how about some numbers? How frequent are they? Alert, I'm going to stand up. Okay, so I'll do it slowly. Okay, can I? I'm getting up slowly now. There is something called the Innocence Project in the United States, based at University in New York, and it's a clinic that does wrongful conviction cases, but they only take DNA cases. So cases where there's DNA that discovered years later, or maybe it's been around for a long time, where the DNA could lead to the exoneration. So unlike other organizations that don't just confine themselves to DNA, they only look at DNA cases. And they're now up to 365, but they looked at the first 330, and these are some of the statistics, and I think it puts into perspective. So the average time spent in prison was 14 years. 92 were sentenced to life, including 12 to life with no parole. And what happens, unbelievably, is there are numerous cases in the United States where people will go from death row to exoneration. Like they literally walk out, and I'll talk about a bit about the impact of that in a little bit, but they literally walk out, the door from death row to going back to the pictures I showed you at the beginning, the vast majority, 80%, were racial minorities. 62% were African American and 7% were Hispanic. Only 5 were women, and we can explore that a little more. Part of it has to do with the fact that these are DNA exonerations, and most of these are murder and sexual assault cases, and sort of a lot of the murders that women are accused of, DNA, it's often their children or their spouse, so DNA would be present anyway, so the DNA isn't available to exonerate. 10% were under 18 years old when they were convicted. On average, they were 27 at the time of wrongful conviction and 42 by the time they were exonerated. 8% pleaded guilty to crimes they didn't commit, and we'll talk a little bit later about false confessions. 85% of those exonerated after a rape conviction were black men accused of assaulting a white woman. In 42% of the cases, the DNA also identified the true perpetrator, but unlike Canada, which doesn't have statutes of limitations, in a lot of the cases in the United States, the actual perpetrator was not charged because of it. And we've had a few of these cases as well. The David Milgard case, which is probably the best, one of the best known Canadian cases. The DNA that eventually exonerated David was later used to convict Larry Fisher of the murder. 20, as I said, 20 were at one time sentenced to death or served time on death row. 47% had spent at least 1/3 of their lives in prison or on parole when they were exonerated. 67% were convicted after 2000, and we'll look at the Canadian situation in a few minutes. But so I told you there's a school of thought that says wrongful convictions are bad, just none of my cases are wrongful convictions. There's another school of thought which is that, yeah, wrongful convictions, but they're all old cases, and you know, we've solved all of the problems that. So most of them were in fact after 2000. 72% were convicted based at least in part on mistaken eyewitness ID, hence the leading cause. 50% of the misidentifications were cross-racial, usually a white person identifying a black person, and in 35%, multiple eyewitnesses identified the same innocent person. Some cases had at least as many as 5 mistaken eyewitnesses. 21% were convicted based at least in part on false confession, admission of guilt, or guilty plea. And 64 of 68 false confessions were contaminated with inside information, whether deliberately or unintentionally. False confessions, sometimes they just happen, but they don't just, in many cases, they don't just happen by accident. There are things, whether deliberately or not, like, you know, someone goes in to do a lineup and, you know, the cop says, oh, good job, you did it, you know. 71% were convicted based at least in part on improper or unvalidated forensic science, and 24% were convicted based at least in part on testimony from informants. This just, again, from the first 325 exonerations in the United States, this, again, eyewitness identification just illustrates it. This is, again, another illustration of the percentage by contributing factor. I mentioned David Milgard, and I'm going to talk a bit about the Canadian situation. How long did David Milgard spend in prison before he was exonerated? 5, 14, 23, or 27? Who says 5? 14? 23? 37? 23. This is a very conservative sample of Canadians wrongfully convicted, and I don't have time to go into the details. I say it's a very conservative sample because it goes back to the point I made at the beginning. To get on my little picture list here, everybody, including the state, has to agree that the person was wrongfully convicted. And you have a lot of cases where convictions are overturned, but there's still disagreement about whether the person was actually wrongfully convicted or not. And a couple of things to look at. In particular, I look at the year of the conviction because Stinchcombe was in, remember, was it 92? But somewhere around there. But you know, did Stinchcombe solve all of our problems? And so the date of conviction, again, to go back to the issue of whether or not wrongful convictions are things of the past. So Donald Marshall, you've all heard of, Guy Palmore and Milgard, 23 years. Herman Caglick, this is significant, at least where I come from, because of all of the other prosecutions are provincial prosecutions. Caglick is the only one on the list that's a federal prosecution. And again, I don't think it's because the federal prosecutors are so much better than the provincial prosecutors. It's just the nature of the offenses that they prosecute. And so his was a sexual assault in Northwest Territories. Softnow, Parsons, Clayton Johnson is the gentleman I mentioned who was convicted of pushing his wife down the stairs. Seymour Marshall, one of the most tragic cases where he was sentenced to a bunch of time for some sexual assaults that he pleaded guilty to. He came out and they were going to charge him with a whole bunch of others, and they finally did DNA testing and found out it wasn't him. Randy Drukin. Bill Mullins Johnson, wonderful guy who comes to my class, not this year, but most years. He served 12 years for killing his 5-year-old niece, and in the end it was shown that she had choked and died of natural causes. And it's unfortunately he's having a bad year this year, and he's not coming, but it's I think over the last 6 or 7 years he's come, and you can see the sort of how his evolution has. Anthony Hannemeyer, interesting story, was convicted of a break-in in a house that was later determined that Paul Bernardo had actually committed. And the reason they know it was Bernardo was because the house he broke into, first of all, Bernardo had he pleaded guilty to a bunch of stuff, but then he confessed to some other stuff that he was never charged with. This was one of them. But the license plate in the car, the house he broke into was Carla, and so he could. Dr. Charles Smith was a pediatric forensic pathologist in Ontario who was the be-all and end-all of pediatric forensic. She's one of the victims, as is Kumar. Maria Shepard is actually coming to my class next week, and she pleaded guilty to killing her stepdaughter, and in the end, she hadn't killed her. And if you're interested, then drop me a note and you can come and listen to her. She's a wonderful speaker. My colleague at the criminology section at criminology department at the University of Ottawa has published a book called Miscarriages of Justice in Canada. In fact, it's the book we use for our course. And she's come up with an estimate of 70 cases. I've gone through her cases, and certainly going back to the issue of trying to get everybody to agree. Lots of people wouldn't agree. I think her number is a little too high, but this is her 70 cases, including 11 Indigenous, and this is from her book again, and my slides will be available later, so I'll pass them along to you. But again, the unreliable eyewitness identification, the leading cause, going back to. And these are some of the Indigenous exonerations in Canada. And one of the things we've started to look at a bit of justice, and a couple of scholars have looked at, is whether there are things in particular that make Indigenous Canadians more susceptible to wrongful convictions. Things such as how they interact with police, language difficulties, and the like. So there's certainly. So how frequent are wrongful convictions? I should start with the second one, and it goes back to the point I made earlier on, which is how willing are we to acknowledge a wrongful conviction? As I said, pretty difficult. But also, part of it is how hard you look. So do you wait for these poor people who are in prison with not a lot of access to materials and stuff? Do you sort of wait for them to come forward and somehow marshal all of the material that they need to overturn their convictions? And we can talk a little bit about at the end about how it is you can overturn the conviction. Or does the state go out and proactively look for them? So I'll give you an example. In the Dr. Smith cases, Ontario's chief coroner did a review of a whole bunch of his cases. And as you saw from the list earlier, a whole bunch of his cases were later overturned as wrongful convictions. Another useful example is the Manitoba hair fiber inquiry. So there was a kind of technology called hair microscopy, which basically allowed a hair examiner to look at this hair from the scene and this hair from the accused, and somehow under a microscope sort of say, oh yeah, they're from the same person. It's now largely been discredited. But what Manitoba did, and subsequently several other provinces did, is rather than just sort of waiting for some guy in prison to be able to marshal evidence, they went out and they did a review. They went through all of their murder cases and then subsequently other cases and looked to see where hair microscopy was used, where the accused pleaded not guilty, and they came up with one or two cases that led to further things. So again, these are you can't just ask how frequent they are without knowing what the state does to try to look for them. I'll just highlight quickly development. You'll see in a few minutes, I don't have a lot of positive things to say about the United States. But one thing that has been developing recently are conviction integrity units. So right in prosecution offices, they're setting up a separate unit to look into cases that people have brought forward as possible wrongful convictions. And they've, I'll show you the numbers, but they have sort of led to a whole series of convictions being overturned. Particularly, not all conviction review integrity units are created equally. Some are better than others, but it's something. And in the heads of prosecution report that Margarita mentioned, we say it's something that's probably worth looking at in Canada as a possible model. So recent estimates, some would say that the number of wrongful convictions is an unknown dark figure. There's something called the National Registry of Exonerations. If you have a chance, Google it later on. It's this, so from January 1989, again, that's the DNA year, to September, they've documented 2,481 exonerations, almost 22,000 lost years. And what's really great about this registry is it has details on each of the cases, but the database you can configure as, so for example, say you wanted to find rural, so you could put it in and it'll give you all the rural ones. Or what about, I want cases where there was eyewitness misidentification and false confessions. And so that the database is really manageable and you get some really great statistics. And again, sorry. So this is a number of exonerations in the United States with official cooperation, and you see, again, it's rising. These are the number of these conviction review units all across the states. So again, the number of conviction integrity units is now up to. I'm often asked, so how does Canada compare to the United States? And I would argue that Canada is doing better than the United States. I'm not downplaying in any way the wrongful conviction problems in Canada, because they definitely occur, and as I tried to explain at the beginning, they're part of the system. But I think compared to the States, we're in a better situation, and I'm just going to, I'll fast forward. No, that's not the one I want. To me, it's all summarized. So this is a confirmed wrongful conviction case of Ronnie and Dale Mahan, and this is the so it's there was DNA, okay, and these are all the factors. This is what the prosecutor said. These sons of bitches are guilty of sin. There's no question in my mind. This is not a case of innocence. These two bastards are guilty. I just can't prove it. So to me, that just sort of summarizes the United States. But a couple of other factors. So why I think we're better off. No death penalty. You would think that if the death penalty is on the table, the person would get the best defense possible and the best trial, but there's huge evidence that that's not the case. And the death penalty just corrupts the whole process. There are recorded cases, I'll talk about So non-elected judges and prosecutors, even public defenders and sheriffs get elected in some cases. You have cases on a Friday where the judge has to decide whether to impose death sentence or life in prison, and the election is Monday.
No.
Guess which way it goes. I'm not in any way defending Canada's legal aid system, but it's eons ahead of what happens in the States. Our Stinchcomb disclosure rules are much better than many states in the US. They're still debating whether to have what they call open book disclosure. We've had 7 commissions of inquiry which have learned many lessons. The 2 main factors, though, are one is the independence of the Crown from police investigations. Our Crowns here have a separate job. So the police do their job, the Crown does its job, and one of the difficult things when you talk to Crown attorneys is, they have to go to the police and say, no, you don't have enough here, and they will often withdraw charges that the police have been. So I think that's a key difference here that really acts as a safeguard. It's not foolproof. We've had wrongful convictions, but it's, and then this is a critical one. Major investigations, going back to the independence of the Crown Police investigation, whenever you see something happen in the United States and they have a press conference, it's often not the police that are holding the press conference. It's the district attorney, and so there's just not the separation that we have. And then major investigations conducted by a handful of police forces and centralization of the criminal justice system. If you've ever driven down to Florida, you know how many gazillion different police forces there are on the way down to Florida. Everything is local in the United States. There's very little sort of province-wide, central or statewide centralization. The number of police forces in the United States is unbelievable. And so in Canada, there's really probably not more than a dozen police forces across the country who do these major investigations that we're generally talking about. So I think that's a difference, and in a lot of them, there's not even state control over the police forces. So I think that's I saw this recently, a lousy picture, but the governor of California, who just declared a moratorium on the death penalty, said, "Why is it we treat the rich and guilty better than the poor and innocent?" I'll skip this. So let me talk for a few minutes about the impacts of wrongful convictions. And obviously, some of them are obvious, but some of them are not. First and foremost, okay, I'm sitting down now. Don't ask me why. Just impacts of wrongful conviction. First and foremost, obviously, the wrongfully convicted person is impacted, and I'll talk in a second about some of those impacts. But let's not forget, so if the wrongfully convicted person is in prison, it means their wife, their children, and their parents are on the outside, and the kids, for example, will go for X number of years without their father. There is some research that has been undertaken recently that looks at the impact of imprisonment on the wrongfully convicted. So yes, prison is a horrible place to be, but if you know you're not supposed to be there, it is qualitatively different than the experience of people who are there wrongfully convicted. And so there's been a lot of research that's looked at the impact of imprisonment on the wrongfully convicted. And they've identified Dr. Adrian Grounds, who's sort of the leading expert in this area, has identified sort of 5 things: post-traumatic stress disorder, enduring personality change, psychiatric disorders, psychological or physical suffering, and readjustment issues. And one of the things that has been interesting is looking at possible PTSD. And there is a woman who is looking at this. She's herself an exoneree, and she, in interactions with my fellow exonerees, I noticed they had some of the same symptoms as me. For example, I developed a tic where I press together my index finger and thumb. It's soothing even though I do it unconsciously. I've realized that the higher my stress level, the more aggressively I do this. I've seen several other exonerees with a similar tic. From the 40 or so exonerees I've interviewed, I've noticed a few trends aside from the hypervigilance and tics noted above. I have yet to meet an exoneree who doesn't have at least one of the following issues: diabetes, irritable bowel syndrome, or hypertension. Certainly they manifest in different ways and in different degrees from exoneree to exoneree. And again, what happens with exonerees is if you're about to be released from prison on parole, there's a process, a gradual process where you're prepared for re-entry. But what often happens in these cases is the door is sprung open. And for example, I've talked about people from death row going right out into with nothing. So Nick Yaris, who spent 22 years on death row, said, "Without guidance, I was expected to settle back into society with people flinging themselves at me with hugs and emotions. It was full on and I had no support system, no money, no job, no qualifications. It was the greatest challenge you can imagine. For so long, I lived in a world where if I expressed anger, someone was going to bust me in my face, so I knew better. Out here, we don't know that penalty, so that's why I'm not bothered by everything I went through, and I learned to control my emotions." So I don't want to belabor the point, but obviously the impact on the wrongfully convicted person and their family, let's not forget the family, is important. But think of the victim, okay? So this is from a study in the United States that said when a wrongfully convicted individual is exonerated, the original crime victim may experience feeling guilt, fear, hopelessness, devastation, and depression. So for, you've been the victim of a sexual assault, and for 10 or 15 years, you've taken some sort of comfort knowing that the person is behind bars, and then one day you get the call, "Oh, I'm sorry, it's not that person." One rape survivor said this: "I was a rape survivor, but what am I now? What do you call the person who messed up the identification?" And a woman named Michelle Mallon, this is what she wrote: "It's been more than 2 decades, but it is still as fresh and vivid in my mind as it was that night. I was a sophomore at Texas Tech, coming back to my dorm on a Sunday night after visiting my family. A man forced his way into my car and put a knife to my throat. He pushed me into the passenger seat, began to drive, and told me he would kill me if I didn't stop screaming. I believed him. He drove to a field in a remote part of town where he raped me. Later, I learned that I was the 5th victim of a serial rapist on campus. A man named Timothy Cole was convicted of raping me and sentenced to 25 years in prison. I was relieved that he had been apprehended, that he would pay for what he did to me, and that our criminal justice system had gotten him off the streets. But I also knew my life would never be the same again. I spent years in counseling and tried to move on with my life. Then last summer, I was forced to relive the entire nightmare, this time with the added tragedy of knowing that Timothy Cole had been innocent and died in prison before he could be exonerated. New DNA testing proved that another man, not Cole, raped me. I was stunned and I was determined to get answers. I put my faith in the criminal justice system and it failed me. I am back in counseling to grapple with the renewed trauma of the rape and the knowledge that I played a role in Cole's wrongful conviction by identifying him as the man who attacked me." We're getting near the end of my time. Just to go back to other impacts. So society at large. So remember that if the wrong person is behind bars, it means the person who actually committed the offense is either on the streets or is in prison for something else. But we've had cases, so for example, in the David Milgard case that I mentioned, Larry Fisher continued to commit offenses after Milgard was arrested. So the impacts are quite dramatic, and it's not just the wrongfully convicted person. I have about 5 minutes, I think. So you've heard peripherally some of the factors that lead to wrongful convictions, and I've just sort of summarized them here. Tunnel vision. Tunnel vision affects everyone in the criminal justice system, but tunnel vision is usually starting with the police have developed a theory of the case, and no matter they just it's a tunnel, and no matter what evidence comes around, they just can't get past the fixation on one person. And there are things that can be done to try to do with tunnel vision. Mistaken eyewitness ID, we've talked about false confessions, false testimony of in-custody informants. I'll just say peripherally, they're rarely used now in Canada. So jailhouse informants, it's not the guy that the police put in the jail. Oh, I forgot to tell you I'm standing up again. Sorry. So it's not when the police put someone in the jail cell. It's the guy who happens to be in the jail cell and hears your confession. And in the Soft Now inquiry, Peter Corey, who was the commissioner, noted that one guy had heard about, 5 different confessions in 5 different precincts. Peter Corey, in his wonderful way, said that this guy probably heard more confessions than your average parish priest. So faulty or unreliable forensic evidence and expert testimony, lack of education. I don't have time to talk about it, but this report that Margarita mentioned is online, and I'll when I send the PowerPoint around, you'll see its recommendations, what police and prosecutors can do to prevent wrongful convictions. It's usually not one mistake, but a combination of events. The same problems, themes, and mistakes happen time and time again. And what's really interesting is when you look at wrongful convictions in any country, those same factors that I mentioned earlier appear over and over again, regardless. And the problems relate to the conduct of police, Crown, defense, judges, forensic scientists, and are by no means confined to proceedings in the courtroom. Catherine Campbell, the criminology professor who I mentioned, I told her I would give a quick plug for Innocence Ottawa. It is a student-run innocence project based out of the criminology department, and basically they've just submitted their first application to the Minister of Justice to have a conviction overturned, they are always looking for volunteers. Right now it's based out of the criminology department. There used to be one here at the faculty, but it's moved on. But if you're interested in innocence work, they're always looking for people to assist in their cases. And just a couple of things I've seen over the years that I'd like to end my talk with. AIDWIC, which is the former name of Innocence Canada, is the sort of the leading innocence organization in Canada. And I was at I think it was their 10th or 15th anniversary, and this guy had this really great t-shirt on that says, "Grief cannot be assuaged by incarcerating the innocent." So on these high-profile murder cases, everyone is grieving loss, and everybody wants someone to be arrested, but grief can't be assuaged by incarcerating the innocents. And this one, I think, summarizes perhaps what I haven't gotten to today, but it takes a gentle breeze to blow someone into jail and the perfect storm to get them out. It's really, once the conviction is set, it's really, really difficult to get it overturned. In particular, false confessions. Once someone confesses, right, good luck trying to, even if they try to disown the confession, 5 minutes later, you try to convince the system that, in fact, they were lying or whatever. So it really is difficult. I guess it was about 10 or 15 years ago, I helped organize an international conference on wrongful convictions. And Erwin Kotler, who was then the Minister of Justice and my boss, said this about wrongful convictions. He said, we're not all to blame, but we're all responsible. So no one in this room hopefully caused wrongful convictions. But I think we all have a responsibility to try to do something about wrongful convictions. And when I talk to, I'm gathering most people here are law profs or students. So to the students in the room, I would say when you become lawyers, think about wrongful convictions. If you become a judge, think about wrongful convictions. Take a second look at the defense theory. Question the eyewitness ID. Be vigilant. Remember, wrongful convictions do occur. And remember, we're not all to blame, but we're all responsible. Je vais prendre tes questions en français ou en anglais.
So, I invite you to ask some questions.
Yes.
Premièrement, merci beaucoup pour la présentation. Peut-être pourriez-vous m'éclairer, je sais qu'il y a plusieurs filets de sécurité qui nous permettent d'attribuer la responsabilité criminelle à la bonne personne. J'ai vu avec vos causes, j'ai compris que c'était facile pour l'identité, pour mauvaisement identifier quelqu'un.
Pas facile.
Ben, ça se peut, puis
oui.
plusieurs exemples.
Oui.
Les causes, c'est souvent pour ça. L'actus reus, je le vois moins, mais je le vois avec les causes. Mais quand on arrive à la mens rea, comment pouvons-nous mauvaisement attribuer la mens rea à quelqu'un? Comment que ça fait que la personne est faussement coupable? Il y a comme dans Wrongful, il y a des crimes qui ont été jugés tellement graves, qui ont mis une mens rea subjective, puis je vois mal comment on peut...
Je vais essayer à répondre en anglais.
Oui,
Most, again, going back to my definition, or the definition, it's not mine, but the definition I used of wrongful conviction, they're not often mens rea cases. You were asking about mens rea. They're either there was no crime, or it's the wrong person. So they're not really, oh, the person was lacking the mens rea to commit this offense. So it doesn't really capture the issue that I think you're dealing with. It's a different type of, all of the on my very conservative list of wrongful convictions, it's not issues of mens rea that get you on the list. So it's a different category of things. Oui.
Yes, I'm curious, you showed a table with states that have these integrity units that are looking at the convictions. How many are in death penalty states, and what is the policy decision behind that? Because I could say if I'm going to put someone on death row for 22 years, it's going to cost the system money.
Huge amounts.
Yeah.
Not so much the imprisonment part, but the trial part.
So how many states are saying, wait a minute, we seem to have trouble with our death penalty issues, and let's have a separate unit reviewing this thing?
I don't know the exact answer. I'll just make a couple of comments. One is, when you look at the death penalty in the United States, there's two factors to look at. One is the number of states that have the death penalty, and I don't know the exact number. But then you have to drill down and look at the number of states that actually execute, and it's minuscule. There are, I think, of the 2019 has been a record low in the United States. But I think the number of states that have executed is like maybe 3. And then you drill down even further, and it's by county. So that even within death penalty states, the number of counties that actually execute. That having been said, and I've talked a lot about sort of my negative views about elected judges and elected legislatures. what you do see because of the election is sometimes these things become election issues. So you actually do see people campaigning for prosecutor, not so much for judge, but for prosecutor on, okay, I'm going to establish a CIU. I haven't seen it linked to the fact of the death penalty, like that correlation. But I am going to look into, try to get an answer to your question about the, it's an interesting sort of connection, but I haven't seen it sort of directly linked. I don't like but there's certainly, for example, the state that has the best sort of wrongful conviction. I'm trying to think of the right word, but they have the best compensation. They have a special commission on forensic evidence. They probably have, I'll look it up afterwards, if not the most CIUs, certainly is also the state that executes most. So on the one hand, they have all this great wrongful convictions. It's Texas.
Well, it goes to your table and you saw Texas with a lot of stars on it.
Yeah. But ironically, they have the best compensation. So maybe someone has made that link. Yeah. But I will look into it because it's a really interesting question. But it's not sufficient to ask who has the death penalty, but it's whether they actually use it or not. That's the...
Yeah, well, thanks, Stephen.
No
it's
problem.
very important work, and I learned a lot today. And one of the facts he said that really troubled me, and I know nothing about criminal law, so to be extremely naive, but it's just that the main cause first of the wrong convictions are mistake by eyewitnesses, right? And when you cross this with the fact that most of the wrongly convicted are racialized people, I find it extremely troubling. So we see that, we can question the reliability of eyewitnessing, especially when it comes to crimes committed by people of color. So I'm wondering, according to you, did you have any thoughts about how we could or should rethink the law of evidence with regard to this factor? And has there been any thoughts or debates about that?
So there are a series of best practices now for eyewitness identification that I haven't seen recently, and forget about the States, but in Canada, we talk about it in the chapter in our report on it, but there's a series of best practices for doing lineups, which there's a huge literature now on eyewitness identification. I went to it wasn't a seminar, it was a round table or a colloquium with a bunch of I was completely intimidated with the leading people on eyewitness ID, including there's some at Carleton, and there's the guru, I forget I'll think of his name in a second, but he was there. He's like, every article you'll ever see about eyewitness identification, he wrote. Like he's just a Gary Wells. He's from, I think, Iowa State or something. So he was in the room, and I was just. But there's a series of best practices, such as number one, the person doing the lineup doesn't know who the suspect is. So whoever the investigating officers are, they get someone else to do the lineup. So there can't be inadvertent. Like forget the deliberate yes stuff, but the inadvertent. So that's number one. Number two is the literature now seems to suggest that the best practice is sequential lineups. So you show, first of all, no one does live ones anymore. Very, very rare. They're really hard to get people, and so the best practice is, so you show picture number one, and the person has to say yay or nay, and then you move it up. Then you show them picture two, and they have to do the same thing, and then picture three and picture four and whatever. So they can't make a comparative examination.
Right.
It's got to be, and there are other things about telling the person that it's possible the person who did this to you is not in the lineup.
Right.
Second, also, there's you're supposed to videotape and the like. So there are a series of best practices that are designed to try to deal with some of the things, and there are some things about cross-racial too. There's a famous case which is Hill. It's a Supreme Court case on Hill. It's called Hill and I think it's Hamilton Regional Police or something, and it was a lineup case where I forget how many were in the lineup, but the suspect was believed to have been Indigenous, and they had a lineup of, I don't know, say 10 for argument, 9 non-Indigenous and 1 Indigenous. So although it's so in theory you come to the conclusion that line was really bad. When you actually look at the pictures, it's not as obvious. But the Supreme Court said clearly, in theory. So there are, and as I say, I went to this symposium. It was here in Ottawa, and there's a very rich literature now on how to do these lineups, which is, and I don't have the exact figures, but many of the large police forces in Canada are now doing that. So you rarely see live lineups, and you rarely have the investigating officer do it. So maybe we're moving.
So hi, Stephen.
Hi, nice to see you. You have to ask me about the first part of my presentation.
Well, no, I wasn't going to ask. Well, no, if my question relates to that first part, please tell me.
Okay.
So I guess that was a very important point raised by Sophie. And the other question that I had was with respect to neuroscience evidence and knowledge that speaks to the way the memory works, human memory, like not only in terms of biases, but just like the way we recollect or remember things. And I'm wondering to what extent those practices, those best practices you were referring to, rely on neuroscience evidence and are informed by the most current knowledge that we have about human memory and the fact that we make up stuff sometimes when we try to remember things.
I answered this question from going to this session, and it seems like it's a pretty multidisciplinary, so that I think they're looking at it. But it raises the question that applies both to false confessions and to eyewitness identification, which is expert evidence. Should our courts allow experts, particularly in jury cases, to be able to give evidence about things that, questionable whether, like for example, memory, as you mentioned, it doesn't work like some people think it is. It isn't like we take a snapshot and, that's forever ingrained. And generally, the courts, both for eyewitness ID and false confessions, have said no, it's not admissible. And there's certainly a movement, certainly within the social science community, to allow. One of the speakers at my class is a guy from U of T who's on this worldwide campaign to get admitted, because then he gets to go to all these cases around the world. Yes, I think the study of eyewitness identification is grounded in the other science work on memory, and it's incorporated, as I understand it, in the best practices. It's certainly they certainly are cognizant of all of the research about how memory works, and it's not as we think it is. It's not just taking a snapshot.
So thank you so much. Stephen, now I can say with more legitimacy that I'm happy that you and Maria decided that you are cross-appointed.
Okay. I mentioned at the beginning that we had a lunch and they're
bureaucracy, great.
Yeah.
So I'm really happy for it. And also, you for a great presentation, and I find it always very refreshing and important when someone like you, who've been working on this for so many years, is revising the definition. I think that's just amazing and great. And
Do you have a better definition for me?
well, I have a suggestion, but it seems naive. but
Can I go back to I'm going to put it on the screen?
Sure.
Okay.
Yeah. Actually, it will help.
Yeah. Hold on, I'm just going to go back while we're going back. So where's Texas? This is Texas, right?
Yeah.
That's Florida. That's it. So it's pretty. That goes back to your question.
Yeah, there's California and East
So, why not a person who is found guilty of a crime they did not commit once all appellate remedies were used?
So going back to my catch-away case, he would, the same problem, I think, because he would still, he wouldn't be caught in as a wrongfully convicted person because it was caught by the system. Like your definition, it still catches those people who have their, like I'm not sure it deals with his case.
So his case, what I don't understand is why we need a reasonable period of time, since it's it has to be wrongful and it's a conviction. So it's not about the time you serve, right? It's about you were convicted. That's it.
Yeah.
Right?
Yeah.
So.
The reason I added the in a reasonable period of time is, for example, I mean the example I used for that one is Guy Paul Morin, who his conviction was overturned by the appellate process, but it took 10 years, which sort of I wouldn't call necessarily a reasonable period of time. So I wanted him to be covered by my definition. But
So the first period of time you served would be considered reasonable? Until
yes,
you got to the
yes,
DNA and everything,
yeah,
so you
yeah.
got-
Now there was a lot of complications in his case because he had a first trial and then there was a second trial and they thought it was Bernardo. I think his defense was it was Bernardo. Unless I'm thinking of a different one. No, I'm thinking of a different one. That's a possibility, but I don't think it deals with the dilemma that caused me to review the definition. So.
And it's an unfortunate consequence.
Yes,
But
and maybe.
as for definition.
Yeah, and maybe maybe no definition is going to cover every possible case, but that may be.
But I might have a very, very simple mind, but why do we have to qualify anything? Like, if a person is found guilty of a crime they did not commit, and even if it's reversed by a court of appeal, even 2-3 months later, the person still live with having been convicted. The people will still believe they did that. With having a hard time finding a job because they made the front page of the paper.
Yep.
I mean, no matter if it's been reversed, they have been, like, factually.
Yep, and that's I think that's where one go if one is concerned about the issue I raised. I think you're right. I think that's where one goes. And my argument, well, if it's overturned on appeal, it means the system's working. It doesn't really matter because the fact is they were still wrongfully convicted.
It's a trial system that should be working.
Absolutely, and I
But
think
it needs to be acknowledged by the system.
yes, and that's
If not, we don't
right,
know.
and that goes back to the difficulty I've talked about all the way through is getting. But I think that's a good point. I think that's if you don't okay, even if you get rid of the in a reasonable period of time. Let's say we get rid of in the reasonable period of time, and we just leave you in. I think that's so either I shouldn't be so obsessed by one case. And then I stick to my original definition, or we go where you go, where you're suggesting we go. Oh yeah, sorry. Yeah, so I think that's either If you're wrongfully convicted, you're wrongfully convicted. And if it gets remedied in 3 months or it gets remedied through the court processes, you're still wrongfully convicted. You still did. So Mr. Catchaway did 3 months and he was still wrongfully convicted, and maybe the definition doesn't need to take into account length of time. I think that's where you go.
Reasonableness, like it
Yep.
depends reasonable for whom. Like
Yep.
I've never been convicted, so I might say, well, it seems to be reasonable.
Absolutely.
6 months would be
Easy
fine,
to
but
say.
jail.
Absolutely. Easy to say it's reasonable when we're on the other side. Yeah, no, absolutely.
Some more questions?
Well, thank you. This was fun.
Thank you so much.
Thank you. I have to do this afternoon for my first class, so it's good. It's a very warm one.
Just give you a small
Oh,
gift
thank you
from
very much.
Our section.
Thank you very much.
Thank you so much.
Thank you.